Who seeks recognition? Gentleman, for what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. You know, last week we saw an attempt to change the rules of this committee that defied the historical precedent of by applying only impeachment proceedings to Attorney General William Barr. And today we're zipping right along, and we know that my colleagues on the other side have the votes. They're gonna try to hold this Attorney General in contempt. But I'm interested to see the look on the judge's face when my colleagues from the other side present these facts. The court's going to say, "What'd you do? Were you in negotiations?" Well, we were, but we scuttled that because we refused to hear from the Attorney General because we changed the rules. You know, Mr. Judge, we changed the rules so the Attorney General didn't come in. He offered to let us view the less redacted report, but I didn't do that. I didn't even bother to go down there and look at that report. He offered to have staff members view the less redacted report with me. I said, no, we're not going to do that either. He permitted us to take notes on the less redacted report, and we rejected that as well. He asked us to continue to negotiate, see if we could work out our differences, but I rejected that as well. We attempted to compel him to respond in spite of federal law on Rule 6E, the grand jury material we've heard so much about today. We knew that there were some other witnesses that were important that might have shed light on this as well, but we didn't hold a hearing with DAG Rosenstein. We didn't hold a hearing on Mueller before we issued our contempt citation. We didn't seek closed-door, confidential, classified hearings with any of these individuals. In fact, Judge, you know what we did? We undercut our whole argument by making the argument to Mr. Barr, saying, hey, look, you know, Mr. Barr, why don't you just join us? Why don't you just join us in asking the court to authorize release of 6E material? What does that do? It says, quite frankly, that the folks that will be sitting there before a court propounding execution of a contempt citation, they're going to have the great privilege of saying, yeah, we put a sword of Damocles over William Barr. We created a Hobson choice. We said, guess what, Mr. Barr? You either get held in contempt or you violate federal law. Because that's just the way we do things in Judiciary Committee these days. That's just the way it is. That is unprecedented and will hold this committee up to derision. And as my colleague, Mr. Johnson from Louisiana said, there was a case that just came out last month which said, and this gets to my colleague from Georgia who said, you can't be misled, there are exceptions. That's right, and the court said you must fit within one of those exceptions before you can release Rule 6E material. But don't be misled, because nothing we're doing here today fits in to the Rule 6E exceptions. There's not an authorization under the 6E provisions right now. So there's going to be a problem, and I can't wait to see the look on the judge's face when these guys try to explain, well, we were trying to pigeonhole into something that's 6E. And then I'll just close in this area. When I hear that the wrecking ball is being taken to the Constitution, that it's being trampled upon, that we're a continued breakdown of constitutional order, these kind of arguments made over and over again, I can't help but say, if you think this administration, this president is so dangerous, why aren't you acting on the mini resolutions for impeachment you've already introduced? I mean, Mr. Johnson was pretty clear. This whole thing is about impeachment. Well, take it to the American people. Take it, file your resolution. You've already filed them. Act on them. With that, my time is up. Thank you.